grounds had somehow impacted on the outcome of the award, but there's no decision being made as to the disqualification.
Correct. That's our view of the convention.
Now I get it. Thank you.
No capacity at that point for a challenge.
Correct. Because at that point, you already have the award issued by the tribunal. So now turning back to the issue of waiver, we could go to the next slide. And this should be slide 9. So on slide 9, we have reproduced ICSID arbitration rules 9 and 27. We had a question from the president who has asked which party has the burden on the issue of promptness. Does the applicant have the burden of demonstrating that its proposal is timely, or does the non-applicant have the burden of demonstrating that the proposal is untimely? As noted yesterday, TECO's view is that the burden is on the applicant to demonstrate that its disqualification proposal has been raised promptly. As Rule 9.1 reflects, promptness is a requirement. It is not an affirmative defense. This makes sense because in a disqualification proposal, there is no opposing party. The arbitrator is not the opposing party. He or she merely is providing observations to the decision maker or makers. The non-applicant, the other party, may not necessarily oppose the disqualification. This does not mean that the applicant is not required to demonstrate promptness. It must so demonstrate, otherwise, its proposal is improper under Article 9.1, and the applicant will be deemed to have waived its objection under Rule 27. Now, the same can be said for Rule 27. The burden is on the party asserting the objection to demonstrate that it did not waive it and that it raised it promptly. This is a requirement that must be met before the objection can be admitted and heard. It is not merely an affirmative defense to be raised by the opposing party. It is a required element. So turning next to slide...
in your view,
sure,
Ms. still have some concerns regarding practical issues. I mean, it all looks good in theory. How would Guatemala show that it had not known? How do you show an omission? How do you prove a negative?
So we will look at some of the examples from some of the other cases in these slides. And what you will see is that other respondent states have pointed to articles in the public domain to show when they first learned, or to when ICSID awards were published, when showing appointments, for example. So showing points in time about when they learned to show we learned it here and we brought it promptly. We brought it within 1 month or 2 months. But they're using information to demonstrate when they gained their knowledge, right? So it's the same type of evidence that we're saying to show you knew or should have known, right? Because it was discoverable by you. It's the same idea.
And they did not do so as a response to a question as to the promptness.
So our view is that they do not need to do that in response to a question because it is a requirement.
I know.
Yep.
It's just in these prior cases where you say states have shown when they knew, referring to publicly available information.
They actually put that in there.
In their request.
Exactly.
Okay.
To show this is why what I'm submitting to you meets the timeliness requirement.
And those cases will be referred to you again in the table, which I asked yesterday. Yeah.
Yes. And then I will get to, there is a slide with some wording to also assist. So turning to slide number 10, which you have on your screen. And this goes to the issue of constructive knowledge. And again, the idea of constructive knowledge derives from the specific language of Rule 27, known or should have known. And I direct the committee's attention to the jurisdictional decision in Grand River versus United States. As the tribunal explained in that case, constructive knowledge of a fact is imputed to a person if by exercise of reasonable care or diligence, the person would have known of that fact. In other words, a party cannot be permitted to rely upon willful ignorance. It has a duty to exercise reasonable care or diligence. As the Grand River Tribunal explains, constructive knowledge is closely associated with the concept of constructive notice. This entails notice that is imputed to a person either from knowing something that ought to have put the person to further inquiry or from willfully abstaining from inquiry in order to avoid actual knowledge. What TECO is arguing in this case is not whatever Nigel Blackaby had in his head. What TECO is arguing is that the copious information in the public domain regarding Dr. Alexandrov, the challenges to him in other cases that were high profile and publicized and discussed on the basis of relationships with damages experts in particular, should have put Guatemala to further inquiry on this issue, as any reasonable party would do in the middle of contentious litigation. Instead, Guatemala admits that it did not undertake that investigation until after the supplemental award was issued. When it did so, it of course found all of the facts it relies upon in this annulment, but those very same facts were discoverable and available to it years before. Guatemala should have brought its objections regarding Dr. Alexandrov during the resubmission proceeding itself. It cannot be permitted to have sat on that objection or keep it up its sleeve, as the EDF committee noted, until annulment. Now, I note in this regard that TECO is not arguing that the disqualification grounds should have been raised within 1 month, which is what I believe we heard this morning. TECO is arguing that there is a requirement of promptness, and that this annulment application was made more than 4 years after Dr. Alexandrov was appointed in the resubmission proceeding. It was not raised promptly, and as a result, Guatemala has waived any right to complain in this annulment proceeding. Now, I want to turn to the issue of the lawyer-client relationship. TECO is not relying upon counsel's knowledge, which is what we heard from Guatemala's attorneys this morning. TECO is relying upon what Guatemala knew or should have known. We are replying to Guatemala's argument that although Freshfields and Mr. Blackaby may have known, that they didn't know. Guatemala's argument is wrong for many reasons. A lawyer has a duty to communicate to his or her client information relevant to his or her interests. Accordingly, the knowledge that a lawyer actually has, as well as the knowledge a lawyer has reason to know, is imputed to his or her client. This is a fundamental principle of professional responsibility. If the client incurs the consequences of the imputed knowledge, which here would be waiver of the objection, the client, depending on the jurisdiction, may have a cause of action against the lawyer for breach of fiduciary duty, a claim for professional negligence, or could file a bar complaint. What it cannot do is use lack of actual knowledge as a defense. And I'll give you an example. If there is a statute of limitations and the time under that statute of limitations has run, a client cannot come before the court and say, my lawyer didn't tell me about it. the lawyer has an obligation to know this and to communicate that information, which is relevant to the interests of his or her client. And so the client may therefore have a claim against his or her lawyer, but that client cannot come before the court and ask to have his or her claim admitted. Another point I would make here is that Guatemala is not a person. It is comprised of ministries, agencies, and officials. So the question here is not whether all of these individuals knew or should have known. The question here, rather, is whether the individuals involved in representing the state's interest, including representatives of the state and external counsel who have been hired to represent the state's interest, knew or should have known these facts. TECO's case is that those individuals, both the state representatives and its external counsel, which in this case was Mr. Blackaby and other attorneys of Freshfields, by exercise of reasonable care and diligence, would have known all of the facts upon which Guatemala now relies. So our submission is that Guatemala, through its constructive knowledge and failure to act in the resubmission proceeding to challenge Dr. Alexandrov, has lost the right to object to Dr. Alexandrov. We turn to the next slide, slide 11. This is, Madam President, the slide I was referring to earlier. So in these three cases, you have Ecuador, Spain, and Pakistan raising objections and referring as the source of their knowledge industry media, including GAR articles, to show the timing of when they became aware. And the point here is that this information in these types of media reports are discoverable through the exercise of reasonable care and diligence. Guatemala did not need to hire a private investigator. It did not need to engage in surveillance, as we heard from Mr. Smith this morning. All it needed to do is exercise reasonable care and diligence, which is exactly what it did after receiving the supplemental decision and after going on a search for annulment grounds. So we turn to slide number 12. We have listed on this side, on the left-hand side, the evidence that you have before you that shows the Guatemala knew or should have known all of these facts, including Dr. Alexandrov's biography, Mr. Kazmarek's CV, various articles, publicly available awards, pleadings, expert reports, and other articles about challenges. All of this was fully available and discoverable. And on the right-hand side, you have all of Guatemala's assertions about Dr. Alexandrov and Mr. Kazmarek that they didn't know. But of course, as Mr. Smith noted, citing Tagar in the past, maybe that meant Freshfields had access. And so finally, on slide 13.
Wait, one question, Ms. Young. I think the argument was made by Guatemala that some value needs to be placed to the fact that no disclosure was made by Mr. Alexandrov. In their view, that no proper disclosure was made by Dr. Alexandrov of its past relationships with Navigant Kaczmarek or whatever.
Yeah.
So that if you don't say anything, the other party, or Guatemala can assume that there's no relationship.
Those are distinct issues. If you are going to bring a disqualification proposal, there is a requirement to bring that promptly. The party has...
It's more the duty to investigate. The way I read,
Correct.
I understood the argument as saying, it's not like you made 3 disclosures, and then, of course, the other party may have a duty to investigate whether these disclosures were properly made. But there's an omission of disclosure. So nothing was disclosed. So if we accepted Guatemala's point, and I'm not saying that we will, it's just in theory, that there was that relationships with experts gives rise to questions as to the impartiality and independence. So that is a ground that should have been disclosed. That's a fact that should have been disclosed. And then there's no disclosure at all. That would mean that in Alexandrov's mind, if he were aware that that is something to disclose, and he did not disclose, that means that there was no relationships in the past with Kaczmarek or Navigant. And the thing is, why is there a need for a party to investigate and go against that presumption that there's nothing there? Hence, no revelation was made. Do you understand my question?
No, I do. And I still would say that these are distinct issues. So if we're thinking about the disqualification proposal or the objection that's being made, a party cannot be permitted to engage in willful negligence or to sit on an objection and keep it up its sleeve until annulment. So the inquiry did that party exercise reasonable care and diligence by making the appropriate inquiries based on what was available in the public domain to make that objection or that challenge in a prompt manner?
Okay, but
and that is distinct from a disclosure.
It's a previous question, and it's when no disclosure is being made, regardless of whether there is disclosure or non-disclosure, is there always a duty to investigate? That's my primary question.
There is a duty to ensure that if you have an objection or if you have something to be raised, you must bring that promptly. You can't sit on it. So there is, of course, an obligation to make the relevant inquiries or to make the relevant investigation based on what is available to you. And we are saying in this particular circumstance, these facts were known, being discussed. He was being challenged in several other arbitrations, which then other cases were then piggybacking off of that very same basis in other cases, that there was knowledge, actual and constructive knowledge of these issues during the resubmission proceeding, and yet no challenge was raised. And so in that instance, you have waived that objection, irrespective of whether this situation was disclosed by the arbitrator.
But Ms. Young, if those were separate duties, disclosure duty, investigation duty, does it mean that every fortnight you need to carry out investigations just in case there was a new situation?
Yeah.
Is this the way you propose this should, or in fact it does happen? I don't know if that's what you do. You have an alarm and every 15 days I need to check whether there's a new case between an arbitrator and an expert.
Ms. Maneker will be discussing the disclosure issue. So I think she will pick up this point during her presentation as well. But I would just again reiterate that the rules themselves, Rule 27 and 9, do impose this requirement. And we've seen in other cases, for example, the Lemire annulment, there was a failure to object to a jurisdictional decision, which then resulted in a waiver of any basis to complain later on annulment. So you do see this when you don't raise issues of which you are aware, it results in waiver. And the whole idea behind this, right, is to ensure procedural economy.
I'm not questioning that principle.
Right.
I'm a step. You need to go a step behind and see whether there was an ongoing obligation to investigate. And we heard here that the disclosure, and you have opposite views, that disclosure and investigation duties are very much connected, because the duty to disclose does not in no way. You say that doesn't discharge the duty to investigate. They say it does. because, and that, so it's an issue whether it's connected or not.
So I will let my colleague, Ms. Menaker, then bring you to the discussion on the disclosure point and address this issue in that context.
And we need to see how practical that is, because in theory, it all works fine. But I just want you to tell me how that's supposed to be put into practice. Thank you.
Understood. So just going to the very final slide really quickly, this timeline, if you go to the next slide, slide 13. It's stuck. Yes. The point on this slide we are depicting on slide 13 is that even accepting what Guatemala had said this morning, its annulment application was not filed promptly. It was saying that it was the ICSID award that, quote, enabled Guatemala to become aware of that situation. Now, we do not agree with that factual statement, but even if you were to accept it, Guatemala did not file promptly. If you look at the timeline, it was still waiting 8 months until it brought this annulment application, which we say is not prompt, and not prompt in when you look at cases like Burlington, and we will provide the chart, and I'm presented to you with the various different timings and what was prompt or not prompt. So unless there are further questions, I will now turn it to my colleague, Ms. Menaker.
So thank you. Again, so I'll just begin by picking up with your question, Madam Chairman, and keeping the distinction between the disclosure obligation and the disqualification. I think the way that it works practically is you get the disclosure from the arbitrator, you review it. In practice, everybody does look into things further. But particularly where you're dealing with the circumstance where there is no consensus at all that this type of relationship is problematic, and therefore it was common, in fact, I would say almost across the board, not to disclose this type of relationship. If you yourself believed that it was problematic, you ask the arbitrator. There are always questions to arbitrators asking to further questions about different circumstances that attorneys will have found or may have found after the tribunal's constituted or after a member is appointed, where they want further clarification. So if this was something that Guatemala thought was problematic, then they could have simply, well, first they could have looked and found it themselves, but they had an obligation then to ask the arbitrator. And that's what happened in many of these cases. If you look, Guatemala has talked about TCC versus Pakistan, but there was a letter from counsel to Dr. Alexandrov asking him about certain information and certain facts. And then he answered, and then they were dissatisfied, and there's a challenge. In Maizen, they said this morning, why did Dr. Alexandrov even make these challenges? Well, first, that was post-ICSID, but there were questions that were
Disclosures, right?
I'm sorry?
Not challenges. Why did Alexandrov make these disclosures?
Disclosures, excuse me. Yes. And there were questions. They wrote letters asking him all sorts of questions, and then he would answer them and then he, because the party kept asking questions, he answered, and then he would go further and say, and while I don't believe this is an issue, because you're asking XYZ, I'm disclosing all of this. So if in their minds, particularly at the time of the resubmission proceeding, which is pre-ICSID, again, you don't have a single decision anywhere at the time when this is happening that this is problematic. If they themselves considered that it was a conflict to have Dr. Alexandrov on a tribunal when Mr. Kazmarek was appearing, or if there was ever going to be a conflict, if you double-hatted and you were sitting and hearing testimony of an expert with whom you had worked, all they had to simply do was ask, and they have that obligation to ask, to look into it themselves if it's a problem, or ask the arbitrator. And then the arbitrator makes the disclosure. But just because an arbitrator doesn't make disclosure does not mean that you yourselves have no duty to investigate, particularly about issues that you may deem to be problematic. And then that is where that comes into play later in the disqualification decisions, because in many of those decisions, you will see, as I noted in opening, it's well accepted that the lack of disclosure in and of itself is not a problem. So in many of those cases, there's been no disclosure. Then they go on to see, well, in the underlying circumstances, are those problematic? Do those manifest a lack of independence or impartiality? And as part of that, of course, they have to look at when you found out, when you knew or should have known of the circumstance or the fact that gives rise to the disqualifying issue, to determine whether you brought your disqualification motion promptly. So they are still putting that, as Ms. Young said, you still have that duty regardless of whether there was or was not disclosure, because, or a lot of times that is sort of a threshold issue that is looked at, but is by no means dispositive. It's not, because you are not disqualified by virtue of not having made a disclosure, nor does it take the burden off of the party to act promptly to disqualify when it learns or when it should have learned of a disqualifying fact.
So you-
how
No, you go ahead.
how is that argument advanced in the context where during the resubmission proceedings, Alexandrov was appearing as counsel in a case where he was using Tomasev, and there does not appear to be any material publicly available with respect to that. You say no duty to disclose that. How is your, if that's the case, how is your argument impacted by an incapacity in relation to that issue to investigate?
And is your hypothetical that the only thing we're looking at is during the process of the case, there is a relationship and there is no materially publicly available information?
Yes.
So that would disregard, of course, that's not our case, because Guatemala is complaining about a relationship that they say has taken place over several years and has talked about many cases, many of which, all of which were ongoing. But still, I think that in the cases that are at issue here, the fact that they were ongoing and the fact of both Mr. Kazmarek's involvement and Dr. Alexandrov's involvement, that was public while the cases were ongoing, and that coincided with the pendency of the resubmission proceeding. So the cases I discussed, for instance, LeaderCon, which they talk about, the Spence case, which I'll discuss a bit. They said today, again, that was during the pendency of the arbitration, as we've explained in our pleadings. That's not entirely accurate, because post-hearing briefs had already been filed before the resubmission proceeding. And so there would have been nothing for the damages expert to do. They were just waiting for the decision of the tribunal or the award. And then you had the Lone Star Fund's decisions. But we have pointed to publicly available information showing the involvement of Mr. Kazmarek and Dr. Alexandrov in these cases that was available while the proceedings were ongoing.
So that will be part of the schedule you're providing at the request of Madam President.
I thought the schedule that we were providing was of jurisprudence as to what different tribunals and the like had found to be prompt, but how much time. I'm happy to provide something else if you have something in mind.
Well, I wouldn't say jurisprudence because I'm sure that is jurisprudence, but previous cases
The ones in the record.
dealing
Yes,
with the
yes.
matter. Yes. But still, I think the question was interesting.
Yes.
Even if it's just a